His name was Harold, 71 years old, retired electrician, 43 years of work. Every Saturday morning, the same thing. Coffee, calculator, savings account. He knew his son. He knew exactly what his son would do with that money. He said it out loud, at the kitchen table, to his wife, more than once. If I leave it to him directly, it'll be gone in a year. He was right. He just didn't know there was a legal structure that could have changed that outcome entirely. One that would have protected his son without punishing him, without humiliating him, and without a single dollar going to anyone else. If you are over 60 and you have a child or a grandchild who struggles with money, with debt, with spending, or with any kind of dependency, I need you to stay with me until the end of this video. Because what Harold didn't know is something most estate attorneys never bring up in a first meeting. And by the time families find out it existed, it's already too late to use it. Before I show you exactly what this legal structure is and how you put it in place, I want to hear from you. Leave a comment right now. Tell me where you are watching from and whether you have a child or grandchild in your life whose financial situation keeps you up at night. You don't have to say their name. You don't have to say anything specific. Just tell me it's there. Because I read every single comment on this channel. And the situations you share with me are the reason I keep making these videos. This is not a channel that talks to a general audience. This channel talks to you, the person who already knows in the back of their mind that there is a problem and has never found a clean legal answer to it. What comes next may be the most important thing you hear this year. Let me start at the beginning of Harold's story, because it didn't start the day he died. It started years earlier, at that kitchen table. Harold's son, Kevin, was 44 years old. He was not a bad person. Harold never described him that way, not once. Kevin worked, paid his rent most months, loved his kids. But money moved through Kevin like water through a screen door. The moment it arrived, it was already halfway out. Credit cards, online purchases, loans he took out to pay other loans. Harold had bailed him out 4 times over the previous decade. $12,000 here, $8,000 there. Each time, Harold told himself it was the last time. Each time, it wasn't. Harold had a will. He had written it himself with an online service 7 years earlier. It left everything to his wife, and if she predeceased him, everything to Kevin. Simple, clean, legal, and completely unprotected. When Harold's wife passed in 2019, Harold updated the will. Kevin was now the sole beneficiary, $178,000. The house had been sold, the proceeds added to the savings, and Harold had moved into a smaller rental. He had worked his entire adult life to leave his son something real, something that would matter. He told his neighbor the week before he passed, "I just hope Kevin is ready for it." Kevin was not ready for it. Within 14 months, every dollar was gone. Not stolen, not lost in a scam, spent. A truck Kevin had always wanted, a trip, old debts that suddenly seemed worth paying off, new debts that came with the feeling of having money. 14 months, $178,000, gone. Kevin is now 47. He has nothing from his father's estate. He has the truck, which he still owes payments on. Here is what you need to understand about what happened to Harold's money, because it wasn't just a story about Kevin's habits. It was a story about a gap in the legal structure that Harold didn't know existed. When you leave money directly to someone in a will, outright, with no conditions, no structure, no oversight, that money becomes theirs the moment probate closes. Legally, completely, irreversibly theirs. What they do with it is none of the law's business. You cannot reach back from the grave and redirect it. You cannot attach instructions that a court will enforce. A letter saying, "Use this wisely," is not a legal document. A conversation at the kitchen table is not a legal document. Grief and guilt are not legal documents. The only document that can do what Harold needed is one that most people over 65 have never been told about in any meaningful detail: a discretionary spendthrift trust. Most people who have heard the word trust imagine something reserved for the wealthy, something that requires a team of attorneys and a minimum of $500,000 to be worth the paperwork. That is one of the most damaging myths in American estate planning, and the financial services industry benefits enormously from it going unchallenged. A discretionary spendthrift trust is a legal structure that allows you to leave money to someone you love, while controlling from beyond your lifetime how and when that money can be accessed. It can be set up to distribute funds for specific purposes: housing, medical costs, education, emergencies. It can require trustee approval for any distribution above a set threshold. And this is the critical piece: it includes a spendthrift clause, which means that Kevin's creditors, Kevin's impulsive decisions, Kevin's history of borrowing against tomorrow cannot touch that money. Legally cannot. The creditors cannot garnish it. A divorce proceeding cannot divide it. A bankruptcy cannot include it. As long as the money sits inside the trust and has not yet been distributed to Kevin, it is protected from every external claim. Harold could have left Kevin $178,000 inside that structure. Kevin could have accessed it for his rent, for medical needs, for a genuine emergency. With a trustee reviewing each request, the money would have been there for Kevin's children. It could have helped with college. It could have been a safety net that lasted decades instead of 14 months. Harold didn't know that option existed. Now that you understand what this structure is and why it exists, I want to ask you something directly. Think about the number in your own estate, whatever it is. Think about the person in your life you have been quietly worried about leaving it to. Have you ever had that conversation with yourself, the one that goes, "I want to leave them something, but I'm afraid of what happens to it"? Tell me in the comments. Tell me how long that thought has been sitting with you. Because if you're watching this right now, that thought has probably been there longer than you want to admit. And what I'm about to show you is the exact roadmap for what to do about it, starting this week, not someday. Here is what almost nobody tells you about setting up this kind of protection. The most common response I hear from people over 65 when they first learn about a discretionary spendthrift trust is this: "I don't want to insult my child. I don't want them to feel like I don't trust them." That response is understandable. It is also, with respect, the wrong frame entirely. A spendthrift trust is not a punishment. It is not a judgment. It is not a document that says your child is broken or unworthy. It is a structure that says, "I love you enough to protect you from your own worst moments. I love you enough to make sure this money is still there when you actually need it. I love you enough to build something that lasts longer than 14 months. The children and grandchildren who benefit most from these structures are not the ones who were cut off. They are the ones whose parents had the foresight to put a framework around the inheritance before they were gone, and who, years later, found that framework to be the thing that kept them housed, kept them out of catastrophic debt, kept the money available for their own children's education. Here is how you actually put this in place. And I want to be clear, what I am about to walk you through is not legal advice. It is what I would tell someone if they were sitting across from me, asking where to start. The first thing you do is identify the trustee. The trustee is the person or institution that will manage the trust after you are gone and make distribution decisions according to the rules you set. This can be a trusted family member who is not the beneficiary, a sibling, another adult child, a cousin you trust completely. It can also be a professional trustee, a bank trust department, or a licensed fiduciary. Professional trustees charge a fee, typically between 0.5% and 1% of the trust value annually. On a $150,000 trust, that is somewhere between $750 and $1,500 per year. For many families, That cost is worth every dollar of peace it buys. The second thing you do is define the distribution standard. This is the language in the trust document that tells the trustee under what circumstances Kevin, or whoever your beneficiary is, can receive money. You can make it broad: health, education, maintenance, and support. You can make it narrow: housing expenses and documented medical costs only. You can set a monthly income distribution, $2,000 per month, regardless of requests. You can include provisions for what happens if the beneficiary enters a debt management program or completes a financial counseling requirement. The standard is yours to define. The law gives you that power. The third thing you do is include the spendthrift clause explicitly. This is the language that prevents the beneficiary's creditors from reaching the trust assets. Without it, a trust can still be vulnerable to certain legal claims. With it, the protection is substantially stronger. Any qualified estate planning attorney can draft this language. It is not exotic. It is not expensive. It is a paragraph that can save a lifetime of savings from disappearing into someone else's debt. The fourth thing you do is act this year. Not when you feel ready, not when you've thought about it long enough, not when things with your child improve, because they may not improve on the timeline you're hoping for. A discretionary spendthrift trust only works if it is in place before you need it. You cannot create it after the fact. You cannot put it in place from a hospital bed if the conversation has never happened with an attorney. The cost of getting this done, a properly drafted trust through an estate planning attorney, typically runs between $1,500 and $3,500, depending on complexity and your state. That is the cost of preventing what happened to Harold from happening in your family. The most common mistake people make when they first look into this is going to a general practice attorney, someone who handles everything from car accidents to real estate closings, and asking them to draft a trust. General practitioners can technically do this work, but estate planning is a specialty, the language in a spendthrift trust, the specific way the distribution standard is written, the way the successor trustee provisions are structured. These details matter enormously. A trust drafted by someone who does this work every day is a different document from a trust drafted by someone who does it twice a year. Ask specifically for an attorney whose practice is focused on estate planning or elder law. That distinction matters more than most people realize. The second mistake is waiting for the right moment to have the conversation with your child. There may never be a right moment, and you do not need their permission. You do not need their agreement. You do not need to tell them the full details of what you are setting up. A trust is a private legal document. You can establish it, fund it, and structure it entirely according to your own judgment, because that judgment is yours, and the law respects it. Most families who work through this process and get it properly documented report a significant shift within the first few weeks after signing. Not a financial shift, a psychological one. The weight of that unresolved question, what happens to this money when I'm gone, lifts, because the answer is no longer, I hope for the best. The answer is, I built something that can hold it. You are not doing this for yourself. You are doing this for your child and for your child's children, who deserve to benefit from what you built, even if your child's habits have never made that feel certain. Before I close, let me tell you what I know about what Harold's story could have looked like. Harold knew Kevin. He had known for years, and in the last months of his life, according to his neighbor, he talked about it often. The worry that the money would vanish, the wish that there was something he could do about it that didn't involve cutting Kevin out entirely. He didn't want Kevin to have nothing. He wanted Kevin to have something that would last. What Harold needed was a 1-hour meeting with an estate planning attorney who specialized in exactly this kind of structure. What it would have cost him was somewhere between $1,500 and $2,500. What it would have produced was a trust document that Kevin could not have spent in 14 months, because the trustee would have been there at every request, reviewing every distribution, protecting the money the way Harold himself would have if he had been alive to do it. The $178,000 would still exist today. Kevin might have his rent covered. His kids might have a college fund. The truck might still have been bought, but within a structure that left the rest intact. Harold didn't get that meeting. His family didn't get that outcome. Yours still can. I want to ask you something before this video ends. Think about the person in your life, the one this video has been about, whether you said their name or not. Is there someone who needs you to still be standing between them and their worst financial instincts for as long as legally possible? Because a discretionary spendthrift trust is exactly that. It is you, still standing there after you are gone. If there is someone in your life over 60, a spouse, a sibling, a close friend, who is carrying this same silent worry about an adult child, send them this video right now. Not after you finish your coffee. Right now. You may be doing the single most important thing you do for their family this year, and it will cost you nothing but 30 seconds. In my next video, I am going to show you something that most families discover only after a parent passes. A little-known provision in federal law that allows certain inherited assets to be structured in a way that dramatically reduces the tax burden on the person receiving them, and that most financial advisors never mention because it requires a legal document, not a financial product. Turn on the notification bell right now. I cannot guarantee this channel reaches you in your feed if you are not subscribed, and that video is not one you can afford to find too late. Subscribe now. The next video may arrive on a day when everything depends on what you know before it's too late. 10 years from now, you will be one of two families. The family that had the conversation, drafted the document, and protected what they spent a lifetime building, and watched it do exactly what they intended long after they were gone. Or the family that meant to, talked about it, kept meaning to get to it, and watched 14 months happen. That distance is not luck. It is not circumstance. It is one afternoon, one attorney, and one decision made before it no longer could be. You know what to do. The only question is whether you do it this week.